I further find that there is no personal jurisdiction over Hart for the pulse chain fraud claims. And this is a big one because this is one that's unique to the other SEC crypto cases that have been out there. This is the alleging of fraud, which, of course, we all knew was probably one of the easiest ones to poke holes in. But at the same time, even though they're just alleging something, it's also kind of one of the scarier things of all. But Judge Carroll says, I further find that there is no personal jurisdiction over Hart for the pulse chain fraud claims as discussed above because the relevant conduct for Hart's alleged fraudulent conduct occurred entirely out of forum. The Second Circuit relies on the effects test. The SEC fails to meet the test. The SEC's allegations of Hart misuse of investor funds and material omissions all occurred abroad. Hart's alleged deceptive acts include misappropriating investor funds between August of 21 and September of 22, and using devices to conceal the funds movement. To the extent the complaint shows that Hart misappropriated investor funds through deceptive mixer transactions, those actions occurred entirely outside of the U.S. The alleged misappropriation occurred through digital wallets and crypto asset platforms, none of which were alleged to have any connection with the United States. The SEC alleges that Hart's material omissions included telling investors about Pulse Chain's development progress and that their investment supported free speech ideals while failing to disclose his luxury purposes. As an initial matter, although the timeline for the Hart's fraud the Pulse Chain fraud claim encompasses Hart's attendance at the virtual conferences and his in-person interview in Miami, the SEC does not allege that these events relate in any way to the conduct underlying its fraud claims. As discussed above, globally available internet content not expressly directed at the United States is insufficient to establish minimum contacts. SEC trying to ruin things for the rest of the world. Accordingly, a focus on the relationship of Hart, the forum, and Hart's suit-related conduct points to the conclusion that there is no specific personal jurisdiction over Hart for the Pulse Chain fraud claims in this case. She goes on, application of the United States securities laws. Even if the SEC had established personal jurisdiction over Hart, which they didn't, Judge Carroll is saying, the complaint cannot stand because it fails to adequately plead that Hart, Jesus, too many hearts in this document, that either the transactions or conduct at issue were domestic under the federal securities laws. Section 5A, sales of securities claim. It is a longstanding principle of American law that legislation of Congress, unless a contrary intent appears, is meant to apply only within the territorial jurisdiction of the United States. In another case, Morrison, a plaintiff therefore must show that transactions at issue were either listed on domestic exchanges or that purchase or sale occurred in the United States. That's not the case here. Hart's crypto assets did not trade on domestic exchanges. Thus, like Coinbase, which is based out of San Francisco, and that's another reason. I mean, this is a topic for another day, but just the whole all Pulse needs to be on exchanges and things like that. It definitely helped us a little bit in this case. I mean, this whole thing was being dismissed either way based on jurisdiction, but still. To establish the existence of a domestic securities transaction and securities not listed on a domestic exchange, a plaintiff must allege facts suggesting that irrevocable liability was incurred or title was transferred within the United States. Okay. Hart contends that the federal securities laws do not apply to the sale of Hart's crypto assets because the complaint merely alleges that an unspecified number of U.S.-based investors participated in the offerings. The SEC argues that irrevocable liability attached when U.S.-based investors deposited crypto assets in digital wallets located on the blockchain in exchange for Hart's crypto assets. In support of its position, the SEC relies on the Second Circuit's recent decision in Williams versus Binance, which addressed the extraterritorial application of securities law under Morrison to transactions in crypto assets. In Williams, the court held that the plaintiffs had plausibly alleged that their securities law claims involved domestic transactions for the purposes of Morrison. Let's hop down here. The plaintiffs alleged that while in the United States, they registered accounts with Binance, accepted Binance's terms of use, and the majority of which of their servers are in the United States. Pursuant to the terms of use, once the trades were matched, they cannot be canceled. Further, Binance disclaimed having any physical location or being subject to any country's securities regulation regime. Binance did, however, have a substantial presence with servers, employees, and customers throughout the United States. Not the case with Richard Hart, obviously. The court acknowledged that determining where irrevocable liability attaches is particularly difficult when a transaction takes place over an exchange that claims to have no physical location in any geographic jurisdiction and not to be subject to the oversight of any country's regulatory authority. Despite this difficulty, the court noted that transactions on such a digital exchange cannot occur nowhere, of course. The court determined that two transactional steps give rise to the inference that irrevocable liability occurred in the United States. That was in the Binance case. Under the first transactional step, the court found it was appropriate to determine where matching occurred solely based on the location of the servers. Binance had not registered any country, purported to have no physical or official location whatsoever, and the authorities in Malta, where nominal headquarters are located, disclaimed responsibility for trying to get to the end of this Binance thing here. I know she's setting up the final blow here, but I'm just trying to read through it. Okay, so she used the Williams Binance case to eventually say, here in the Hart case, unlike in Williams, the complaint fails to allege that investors' deposits were matched on servers in the United States. Binance is an exchange. There are servers in America. Nor does the complaint allege that the deposits were first validated on the blockchain in the United States. You can't. We don't know where it is. Thus, the complaint fails to satisfy the first transactional step under Williams. The SEC interprets Williams, however, to stand for the proposition that sending buy orders and payments from the United States is a second separate basis to establish irrevocable liability. Therefore, under the standalone basis, irrevocable liability occurred in the United States when U.S.-based investors deposited crypto assets into digital wallets on the chain. In response, Hart argues that the Second Circuit expressly observed that placing purchase orders from the United States was only a second interrelated reason to find that the irrevocable liability attached in the United States. Whether it is or is not an independent basis to show that the parties have irrevocably bound within the United States, there is insufficient allegations to apply this basis. First, the Second Circuit specifically expressed that we have reason here to consider where the trades originated because Binance expressly disclaims having any physical location, and therefore the sovereignty and committee concerns are less present. In this case, Hart made no such disclaimers. Rather, the complaint alleges that Hart is a resident of Finland. Unlike Malta's express disclaimer of regulatory responsibility over Binance, Finland is not alleged to have made any such disclaimer. Matter of fact, Finland hates him. Further, the SEC attempts to assert in conclusory fashion that the transactions took place in the United States. The investors did not enter into terms of use with Hart. Instead, the SEC relies on allegations that investors deposited crypto assets into digital wallets, including from the United States, and which is insufficient. Courts have required far more U.S.-centric allegations to show that the crypto asset transactions at issue were sufficiently domestic. She goes on. I'm not going to read this whole other case. She explains why. I acknowledge the Second Circuit's concern that transactions on a digital exchange cannot occur nowhere, but as alleged, I cannot reasonably infer that these transactions occurred in the United States. Well said. Where does the blockchain live? Famous Carol quote. Accordingly, the SEC has failed to adequately allege domestic transactions for its claims. This is outstanding. If you're just tuning in, just reading over Judge Auntie Carol's decision to totally dismiss this. Yeah, fresh and fit. I see in the comments now. Thanks, guys. And I mean, man, she is just shutting them down. I mean, her attitude in the courtroom that day is really coming out. Not attitude, but the way her opinions seem to be is really coming out here in this document. So